Welcome back, everybody. My name is Jonathan Mayorca, aka Johnny Tsunami on the ones and twos. Usually behind the scenes, making everyone look beautiful, making Pasta and Fiorello look amazeballs. But whenever I come on, I let you know it's for a good reason. I also do my fair share of journalism, and this story is very special today. Today we have a very special guest. He's, from his website, he says that he's a seasoned aviator and educator and entrepreneur, but above all, a humanitarian. In my eyes, a true patriot, friend of the show, fighter of the people, true rebel, Raji Rob.
Thank you. Thank you so much, Johnny. I appreciate it.
Absolutely, absolutely. And on March 3rd, so we're here, we want to discuss the elections. So I kind of just wanted to invite you on. We understand you're working on a court case, but let's start from the beginning a little bit. So I'm gonna kind of run down this uh, the sequence of events. So on March 3rd, 2020, Los Angeles experienced one of the biggest desecrations of our rights in history. Um, when we discuss, we're going to discuss a little bit about what happened leading up to the election. So let's discuss how we got there. You have a sequence of events here, and so you ran for seat of Congress in District 30, correct?
That's correct.
Brad Sherman was your main opponent, and he and the winner of the election. So you ran your campaign, and you admit with high confidence that you would win. Come 2020, new system put into practice. New ballot marking devices were launched on this election, aka really expensive devices to mark ballots, right? 11 days given to vote early. We found that was false, particularly in poor areas such as Paramount, where Pasta and I saw that the voting centers were not properly set up. Huge reduction of voting centers available to everybody. They went from over 2,000 voting centers in LA to approximately 978 voting centers on election day. And only 231 of those voting centers open for early voting. I was able to figure this out from the list of locations available on their site. And that's only 23% of the voting locations available from February 22nd to about 3 days before March 3rd. So there were ballot marking devices failing on the first day to vote in late February. There was an independent report on these machines that they failed the own Secretary of State's requirements for paper jamming, correct?
Correct.
Yet they still used them. And there was a huge
they use them with conditional approval. Now, this is where the Secretary of State comes in. You cannot use something as conditional. What? So the primary elections don't matter? That you're going to go ahead and just give something a conditional approval, something that has failed the test, and say, okay, we'll now fix them for the general election, meaning like the all this time for the primary election doesn't even matter. And we're talking about $300 million spent here.
Exactly. That's what we're talking about. And so let me see. I just lost my place. So they approved those failing machines. Failure of notifying the public that they can vote early. There was no social media campaigns. There were no. There was the scarce billboard ads. A few radio stations that said that you could vote early that I heard. Come election day on March 3rd, what happened? Long lines, 3-hour long lines, ballot marking devices failing left and right, provisional ballots being handed out to a lot of people, conditional ballots, which is the same thing as provisional, basically, being handed out to everybody. We saw this the night before in East LA, which is a predominantly poor area they had so much time to get this right. Not even just time, but money, as you said, $300 million.
It was set up for failure. It was designed to do what it did. That was the purpose. And it has been the pattern to discourage people from coming out and voting. Asking for IDs at places where, the situations were tight, people were in line, they rushed, the parking issues and whatnot. It's not just the constitutional right, it's the sentiment, it's the essence of going out to vote that has been discouraged in a set up pattern over the years.
And provisional ballots, they're handing them out left and right. Extra scrutiny. Provisional ballots are bad because they require extra scrutiny in a dark, secret room that no one can even see. You can't even bring cameras in there.
The whole process, the moment the entire paperwork goes back into the LARRCC, you don't know. It's behind closed doors, and the past is so dark and so evil that you can imagine that anything going in there, don't expect any transparency at all. I've been there, I've seen it. They just close doors on you. They don't want to talk to you. They just want you to go away.
Exactly. That's how it was when me, Pasta, and Fiorello went to go see the thousands of provisional ballots that were in that room, and there's workers working, and most likely they don't get counted for some bullshit reasons. Address changes or signatures not matched, or if you have just a slight variation in your signature.
It is discretionary. Everything is discretionary. They'll pick and choose what they want. They promise the American people that if people are not trusting those machines, they will be given paper ballots. No such thing was available. They started pushing provisional ballots, and this is where everything went south from that point onward, because people were so agitated. I saw people screaming and shouting and said, "This is the worst election they've come across. This is voter suppression. I can't be in line for more than 3 hours." Like I was telling you earlier, so many women I saw. I said someone had to get some medicine from the parents, from grandparents, picking kids up, and it was like this has never happened before. But I did not see any sign of remorse or any apology from Registrar Dean Logan, who's the boss of this election process and who has been given a free oversight, a complete free hand by the Board of Supervisors and the Secretary of State. It is really shameful.
It is. It is. And so, the election was a disaster. It was a disaster. And, all these reasons we listed here is mostly from us at the Convo Couch and True Rebel Network, what we observed and documented. Same with Raji. Now, let's discuss what you really saw, Raji. Let's discuss how you came to see that fraud was detected to be going on.
I would like to go back a little bit, just backtrack a little bit. Just a few months before, I started to get the vibe on the blogs where people are on talking to LA and the Registrar Dean Logan and what kind of response was coming out. And, all the backdrop was you could feel there's something brewing in the background, a massive election fraud is going to take place. And I put it out on social media. I made, article in the newspapers, San Francisco newspapers and others making out. I put up a lot of ads out there that, look, people, watch out. Something is going to happen. Be careful. Take a photograph of your vote by mail or whatever you're doing, because this is going to come down to this, that you will need evidence. So as it was going on, I was already careful. And at the night of the election, I was looking for some place I could quickly get a short line and get out of there. I couldn't find any. Places were loaded, which was good to see that democracy was bubbling. But also at the same time, people were so, I saw a lot of resentment with people who were walking away. I put 2 hours in line, and as I was walking out, there was already a 2.5 hour line behind me, and this was like 8 o'clock, around 8 o'clock, that I did my I did my voting. So as I was on the way to the Downey vote count site by the Los Angeles Registrar Dean Logan, I was shocked to find out I had two of my team members with me who were constantly checking the results, and they said, "Oh my God, they already announced the results." I said, "Who announced the results?" New York Times. Now, New York Times is a very reputable organization. You don't expect this from them. They did that. They announced the results, and I started getting calls from people saying, "What happened? What happened? What happened? What happened?" Like, is it true? Because people were still in line.
Yeah, and that was the night of the election.
Yeah, night of the election, and everybody was so shocked that how is it possible when the ballots haven't even left the precincts? How can this be announced? And so the first thing I asked when I arrived at the Downey site was, I came across Alex Olvera, who is the divisional manager, boss of the election systems over there. And I said, Alex, did you guys already announce the elections? Because how's it possible? New York Times already announced the elections. And he said, no, we haven't. We haven't received anything. It's, it's less than one person reporting right now. In fact, he said, we haven't received anything. So now this is the time where I got an opportunity to speak with them. I said, so when did you start counting ballots, Alex? Uh, and then he responded to me in a very, twisted tone. He said that we started processing the ballots 10 days before the elections. At this point, I challenged him and I asked him, could you please define the term processing? And
Process.
yeah, so he started to give me, a run around on that description, and I asked him to bring in the rule book which describes processing.
Yes.
So he went and brought out election code, the book, and I'm aware of that because I fought this election battle in 2018, and I'd gone through the election codes. I said, "Look, Alex, it's very clear here. The word processing is very clear, and you know what it says is I'm going to show you on the screen. Uh, there is an election code which is called 15101B. I'm going to put it just for a second,
Okay.
so that can you see it?
Yeah, you know what? I can actually access an election code here. Let me see. I'll pull up the petition that you started
You
here.
will see 15101B. I'm just putting it here so that people can look at it and you know what I'm talking about. So in this election code, it describes not only processing, but it also describes that under no circumstances can you access the ballot result. Under no circumstances. But what they did was, what Alex did and what LARRCC did was they used the word processing and they said, oh, we just did scanning 10 days before. We didn't count the ballots. And they were trying to lie, to make a total misrepresentation on what they did. So what they did was, he said they started scanning ballots 10 days before the election.
Yes.
And with what? With a machine that is two-in-one scanner and tabulation machine. So what you're doing actually is you're counting the ballots 10 days before the election and using the term scanning. But these machines do scan and tabulate together. Like when you have even a simple printer and you scan or some, copy, it'll start giving you the numbers. And these machines have, monitors, and they have the capability of scan and tabulate at the same time. So this is where the major fraud happened. The essence of the 15101B election code is that all the ballots are counted 8 p.m. election night or election day, 8 p.m. So there's no time to cheat. So I had another person who was in San Bernardino County, and I took a declaration from him also that what happened there is they said, no, they kept the ballots on the side and they counted all the ballots at the same time, 8 p.m. election night. Because when you count election 10 days before the election day, you have so much room to play havoc with the numbers, with the vote change, with the entire election results as fraud. Because the moment you make one violation of the election code, you have just opened the Pandora box to do whatever you want.
Exactly. So I actually have it up here on the screen. So I'm going to just read it here. It says, election code 15101B. Any jurisdiction having the necessary computer capability may start to process vote by mail ballots on the 10th business day before the election. Processing vote by mail ballots includes opening vote by mail ballot return envelopes, removing ballots, duplicating any damaged ballots, and preparing the ballots to be machine read or machine reading them, including processing write-in votes so that they can be tallied by the machine. But under no circumstances may a vote count be accessed or released until 8 p.m. on the day of the election. Your allegation is that they not only scanned the ballots, they tabulated them, so they got the results.
And also, what is important in this election code is the fact that the envelopes for the vote by mail. Now, vote by mail, that's 60-70% of the total vote cast. So vote by mail decides most of the stuff here of the election results. So what it says here, 15101B, is It describes what you can do very clearly, that you can open ballots, and what you do is duplicate damaged ballots. That's the reason you're opening the ballots. That is this one damaged? Okay, we can duplicate it. And duplicate it, the next word is preparing. I'm going to read it. Removing ballots, duplicating ballots, any damaged ballots, and preparing the ballots to be machine read or machine reading them. So basically, what are they saying? They're talking about the word preparing. If you read it, clearly, it's the whole thing is about all those ballots that are damaged. You just open them and prepare them for the machine read or machine reading them. You don't start scanning them. It doesn't say anywhere. You can't tabulate them. It's very clear that under no circumstances, may a vote count be accessed. But the moment you start tabulating, you access the ballot count right there. So what they did was they scanned and tabulated the ballots 10 days before the election. They accessed the ballot count and they changed the results. And it was very obvious why they were lying to all this. They should have just informed the people, hey, we're going to start doing the ballot count 10 days before. Why you guys don't come and observe? So at the night of the election, Alex Olvera, the chief of operations officer over there, who was the divisional manager, he was the boss that night. And he lied so blatantly, trying to cover up the mess that they were into because of my questioning. And he said he went back and twice, a couple of times, telling me that, oh, first he admitted they were 2-1. Then he said they are not 2-1. And then he said the tabulation machine is done in another room. And every time he would go and he said, let me go and ask my boss, who is Dean Logan himself.
Yes,
And he
yes.
would come back and say, you know what? And then finally he said, I don't have the password to look at the results. I said, then who has the password? So there was so much of constant lying about this aspect of these machines having the 2-in-1 function.
They were acting very suspicious when you were talking to them.
Yes, and especially when Alex left the room and I asked another official, and he clearly told me after speaking to Jeff Klein, who was staying next by, that these are 2-in-1 machines. And then later I spoke to other people who confirmed that these are 2-in-1 machines. And when you scan them, you'll get the results. So immediately, doubt comes in. And why should we give them the benefit of the doubt? Why should we accept what they're saying when they're not showing evidence? The only thing that should be right now that should meet the me eye to eye is the fact that give us the information about the machine. Is it 2-in-1 or not? If it is 2-in-1, then you guys committed fraud under 15101B.
Yes. Okay. So you felt that there was fraud, and I agree that there's fraud and also voter suppression and everything else. So you actually went to the court. So let's just go through the sequence of events really quick, and so our viewers know about this whole process that you've gone through here. So basically, here we are, full screen. On March 3rd, 2020, election fraud detected at the LARRCC, because you were there in person and you detected that. And then you said the next day, 1%.
I had evidence. I have witnesses there too with me that night.
Exactly. And then the next one says 1% manual tally not done on March 6, 2020. 1% manual tally done on March 7th, suspiciously without any transparency. Didn't you go there in March 6th, and then as soon as
I was there on March 6th from morning till about 4 o'clock in the afternoon, evening, waiting for them to start the tally. And around 4:30, I was told that, oh, you know what, we're not. They kept delaying it, and they said we're not going to do it today because our printers are not working, and we're going to do it tomorrow. I said, are you really guys going to do it tomorrow? Are you not going to start right after I leave? Because this is what had happened earlier in another election when they didn't do the tally at all. So I came the other day and they started the tally, but there was nothing transparent about it. It was a complete hoax. It was a complete dog and pony show. Believe me, there was nothing there that I could relate to as official. So I asked questions, and everybody was like so tight-lipped, and they were probably instructed not to answer my questions. I couldn't find any tally sheet like the. So the purpose of the 1% tally is to confirm the transparency and the integrity of the election. So what they do is, here's the election night result, and here is the result that we tally today, and they match. So, but what they were doing was there were no tally sheets at all. There was nothing to compare with. It was completely one-sided action where they were just doing something for the heck of it. They were just following through with it was just a show. And I was there all day. I was shocked that nobody was talking, nobody was telling me I'm supposed to be, and I was the only one over there. And I was asking, please show me, what are you comparing these uh, uh, results with, hand count results with, or manual count results with? Because if you don't have something to compare with, then this is all false. So that was the thing. The entire 1% tally was a complete sham.
So, yes, it was a sham, and basically, the next on the 9th, there was the protest which you went to, which I have a picture here of LA protesters, voters protest outside of election officials' office. So you went to that protest where you spoke your mind. And we dropped off a what's it called, a
A
complaint.
complaint. Yeah.
So we dropped off a complaint, and then on March 10th, there was the LA Board of Supervisors.
Yeah, I was there, and a lot of people were there who waited 6, 7 hours for just a minute to speak, and those 1 minute speeches said it all. I did the same thing. I made a brief complaint. I handed over to the board of supervisors that day, and I was expecting something to happen. And later, I made a formal complaint on March 26th, and I gave it to board of supervisors, Secretary of State, Dean Logan. I yeah, that's the one. And then there was one on the 26th, which was a little bit more in detail. And I was asking for questions and answers. And I received a letter from county council on behalf of Dean Logan saying that, you know what, we're going to give you all your answers by April 24th. So I had a feeling I'm not going to get any answer. I started contacting the courthouse. Now, meanwhile, COVID-19 uh, and the national emergency crisis was announced, and the courts were closed. So I kept calling the courthouse. No information, no answers, nothing on the website. I said, you know what, I can't wait, and I filed by mail my case. And I wrote a letter to the boss of the courthouse, the presiding judge Russell, great American, great guy. I, I am so grateful to this person that he accepted my case by mail, issued a case number, and assigned my case to a judge. And I received a confirmation by mail. But then, the worst part was the judge that was assigned my case the next very day overruled the presiding judge's order that, oh, I'm not allowed to file my mailings by mail. So I called the courthouse, Department 21, and I said, look, there's a pandemic going on, and you expect me to take a flight to Sacramento or 8-hour drive to drop an envelope in a Dropbox outside the court? And she said, yes, this is what we want you to do. I said, you know what? I think I'll have to write to the presiding judge again. And suddenly everything changed. Suddenly I get, okay, wait. You know what? The judge is going to accept your mail filing. I filed a TRO by mail, that is temporary restraining order, for the opposition to not mess with evidence,
The
to stop.
opposition being Secretary of State and Dean Logan and all the
Yeah,
election officials.
I what I said was this entire certification is false, because before they certified, I filed the case and I had sent them a copy that writ of mandate election contest on fraud has been filed. You're served. So what you do in such cases is you come out open and say, you know what, I'm a Secretary of State. There's a complaint in the courthouse. This guy's taken the trouble to come from Los Angeles to Sacramento. I'm going to listen to him and say, hey, what is it about fraud? What do you want? Come and check us. No, what I get is immediate block. Stop this guy. Stop him, because we have to hide something. And what happens? This judge takes over the case, and she gives uh, a briefing schedule where the other side has to file opposition to my TRO, and then I'm supposed to answer to their brief. So there's a date of 22nd uh, May and 4th June. 22nd May for them to respond to my complaint of TRO, and 4th for me to respond to their responses. But what happened in the meantime? I saw what was going on. I filed 160.0 170.6, a complaint to the judge under which you have the right to say, I want to change the judge. So I did that, and I wrote it to the presiding judge as well, and the judge was changed. The outgoing judge, what she did was she completely vacated the briefing schedule under which first party was to respond by May 22nd, and I was supposed to respond by June 4th. So that order was vacated. That means now nobody's supposed to answer to anything.
Right.
And I was expecting new briefing schedules to come out. But the opposing party was, they waited for the last day to file their responses. So their responses came in. They didn't, by the time their responses came in, the order was already vacated.
Yes.
So, and I didn't have to respond to that because they were supposed to respond by the 22nd. 22nd is when the outgoing judge vacated the order, and I was supposed to respond by June 4th, but that order was vacated, so I didn't have to answer to nothing. And
so real quickly, to just put it in layman terms, because some people don't know how the courts work.
Yes,
so
please.
First of all, you sent a complaint to the Board of Supervisors. Janice Hahn actually made a statement, and she said that people waiting to vote in line for 2 or 3 hours to vote, e-poll books not syncing properly. She recognized all the plights that you talked about. You sent a complaint, which isn't a court anything that does with the court, right? Then you sent the complaint to the LA Board of Supervisors, the Dean Logan and Secretary of State, and then you did a writ of mandate, which that's when the courts get involved. The writ of mandate being that you wanted a TRO, a restraining order on everybody to not do.
I filed the writ of mandate about the case, and then I filed a TRO because of the pandemic. The courts are closed, so everything was like a little haphazard, and I'm fighting it on my own. I wrote to the presiding judge; he accepted it. So I sent the TRO. The judge came and she tried to strike me down right there.
Right. And so second judge, just the judge that received it, tried to strike it down, say no, it's too late. We need you to hand deliver it to the courts.
Yeah, exactly. The first judge, Russell, the presiding judge, was great. He accepted it, but the second judge who came in, who was assigned the case, said, "No, you have to come down all the way to Sacramento and deliver." And then I said, "Okay, I got to then talk to Judge Russell again." And what happens is suddenly they say, "Okay, we're going to handle the TRO." And TRO was supposed to be ex parte, meaning urgency. You decide right away. And she gives them 2 weeks to respond, and then me to respond 2 weeks to them as if it's a very casual matter. So I said, and then this judge was also, had been a deputy attorney general, worked with the Secretary of State in the past, his office. I said, no, it's not going to work. I requested change of judge. I got it. And when she left, she vacated her court order of the
and doing that. That's like, so you had a schedule of when everyone was going to respond and everything. So the judge that left vacated that. So then that schedule doesn't matter anymore. And then the second judge that came in was like, "Oh, the party responded and you never responded." Then you're.
So I used the time to file an amended TRO, an amended writ, which I have the right under the laws. You can do it one time.
Yes.
And so once I filed it, I informed the opposition that, excuse me, I filed amended TRO. This is for your information, and you should have received it. The opposition, Secretary of State attorneys and Registrar Dean Logan's attorneys scrambled to the courthouse because they couldn't find my amended TRO, which was lying in the clerk's office. So on the 10th, they found it. On the 10th, judge received it. On the 10th, judge ruled on the TRO. And this is where we come in now. This is where the plight is. This is where I'm reaching out to the American people, because there is a court of law and there's a court of people's law also. People voice, people's judgment is extremely important, which gets set aside. So I have my case there, but I also want to bring it to the public, because ultimately they are the ones who are going to be affected with the outcome of this fraud elections.
Right. Okay. So yes, you were able to get it in, and then she responded to the original TRO, which she responded, right? It was a court order.
She responded to TRO, and the way she responded is like she hasn't even read anything. And then she respond to the TRO by starting the TRO. Um, I'll just bring out the important features of the. She denied the TRO, and the reason that she gave was, she said that you were supposed to answer to the response of the opposition by June 5th. You didn't do that, and instead you filed the amended TRO without realizing, without looking at the record. She completely exceeded her discretion. She overlooked the court docket, and the very first order that was vacated by the outgoing judge, that I was not required to answer to anything by June 5th. But she used that, and she accused me of not complying with the court order and not answering, which wasn't there. It didn't exist anymore. It was vacated, it was deleted. So, and then from there onwards, you have the court order with you.
Yeah.
The judge went over and over about procedural,
Yes.
attempt to completely dislodge my case.
Yeah.
And every time she would do it, she would use the responses filed by the opposition.
Exactly.
By
So
saying,
I actually have it right here. So let's take a look at it. I
yes,
wanted to go.
let's go
I
in
wanted to
sequence.
go. I wanted to go through it. So
Yes.
here we have it, and I highlighted a lot. So I read through it and I highlighted a lot. So the application is denied for reasons stated below. And deciding whether to issue a preliminary injunction, the court considers two interrelated factors: the likelihood petitioner will prevail on the merits, and the interim harm the parties will suffer in an injunction is not issued compared to the interim harm if it is. So basically, what they're saying that they denied it based on on two factors, which is how likely you are to win the case, and then how it will affect the defendants.
The harm. Yeah, both sides. I'm asking for that. If you don't do this, I'm going to be harmed. Public is going to. There's going to be irreparable harm that's going to befall upon us all. So what she did was she quoted a law that these two factors she's going to use, and then she completely swings around and without any evidence and attacks me and
Exactly.
attacks me over and over again that you're not going to prevail. You're not going to prevail. You're not. You're a judge. You have to see that this guy is alleging fraud. I'm not saying that there's an irregularity. I'm not saying there's a negligence. I'm saying there's blatant fraud. And if there's fraud, that means everything is fraud. You cannot say in that you're not going to prevail on the basis of what? There's no harm going to befall upon you. Of course, there's going to be irreparable harm that's going to fall upon me if you don't issue a TRO, because my main ground was these guys are going to go and mess with evidence. They're going to tamper with evidence. So the TRO was not saying that I won. The TRO was, please stop them from tampering with evidence. Please stop them from printing ballots for November. Please stop them from certifying the election, or if they have certified them, vacate the certification.
Right.
So those are the points that I was asking.
Exactly.
And here the judge, without even looking, you'll be surprised if you go step by step, and I'm going to answer your questions.
Yeah, let's go step by step. So basically, it says petitioner has the burden of establishing both that he has a reasonable probability of prevailing and that the balance of harm tips in his favor. Because a TRO, a temporary restraining order, and a preliminary injunction restrain the defendant's actions prior to the trial on the merits, they are considered extraordinary and drastic remedies and will not be granted lightly. Let's keep going. This case involves an elections contest and special rules apply to such cases. So it sounds like they're already denying it in the first.
The worst part is that she is not looking at the complaint is about fraud, and the case laws that the judge is presenting is not about fraud. You see, there are millions of cases. You could go and pick one, dozen pages, and print them out and put there, but they're not about fraud. And I have put reasonable case laws in my responses to say, first of all, you're saying there's no justification. The number one justification is that I'm alleging fraud, and I'm saying this has happened, and I have declaration evidence. The biggest evidence is a witness has given a declaration under oath. That is evidence. The other evidence is operating manual, which is in the hands of the opposition. So instead of weighing them out, completely exceeded discretion. Judge exceeded, court exceeded discretion. I'm not trying to make any personal attack, but I have to defend the American people here and to say that the court exceeded jurisdiction. completely neglected, overlooked the fact that there's big fraud alleged in this election. And
Now,
on the basis of evidence. It's not that I'm saying, oh, there was fraud because I lost or somebody else won or that. No, because they broke the law, they counted the ballots, and once I'm proving that, that should be enough for them to look into and they should be listening to me, not pushing me aside.
okay. And then it says the election must be held valid unless plainly illegal. So California law makes it hard to overturn elections. Voters, not judges, mainly run our democracy. The courts have thus a very high bar for election challenges. Petitioner has the burden of proving the defect in the election by clear and convincing evidence. So what they're saying is that you got to pay. How do we get that clear evidence?
Yeah, there you go. So first of all, she used the word unless plainly illegal. And this is what I'm saying. If you read the line there somewhere, she said, unless the election is plainly illegal. And that's exactly what I'm saying. The election results, well, I'm not talking about the election, I'm talking about the counting. The election results were completely illegal because they were counted fraudulently. They were counted before election day. You're not supposed to do that. If you're doing that you cannot come and say, well, we did count them, but we didn't look at the results. No, you broke the law. It stops right there. I
Yeah,
cannot.
because we don't know if they looked at it or not.
There is no knowing to what extent they went once they broke the law, because I we don't have witnesses watching what they're doing, but we can see that they broke the law. Nobody can do that. Even you even the cameras that you put in, are operated by them, so you can't tell. But one thing is for sure, that you're not allowed to count the ballots before 8 p.m. election day. They did that.
So, and then it says requires a high finding a high probability that the evidence be so clear as to leave no substantial doubt. But there's there's no transparency. So she has the power to make a court order to make it more transparent. Now it says with these rules in mind, the relevant facts are as follows. So this is when they start their argument. So on April 8, 2020, petitioner filed an 84-page petition for writ of mandate, raising numerous challenges to the election. The court discusses the allegations in this petition in some detail because petitioner's application for a TRO and OSC provides almost no information about this case, much less demonstrates that he is likely to prevail on the merits. Down here below, it says petitioner seeks a writ of mandate ordering respondents to set aside the results of the primary election and to conduct a manual recount of the votes. He also asked the courts to prohibit the printing of ballots for the November 2020 general election until the recount is performed. In his application for a TRO, he asked the court to prohibit respondents from certifying the results of the primary election and from printing ballots for the general election pending a decision on the merits of his petition. The election results are certified on May 1st, 2020, which arguably renders the first request moot. And then down here in the footnote, it says, although...
I can't believe it. I can't believe it. But also, I want to point out, step by step. Now, she says no information has been given, right?
Yeah.
So I responded to her yesterday and I mailed it out. And I pointed out that, Laura, where is number 9? Okay, I got it. So I pointed out exactly how many times that I gave the information that she's saying no information is given. So I said, she amended ex parte TRO application page 4 to 7, line 3, page 8, line 20, 21, page 9, line 25, page 10, line 25, 26, page 11, line 16, 17, page 14, line 24, 25, page 8. That many times I explained what about the case, and she's saying absolutely no information about the case, and I mentioned it like a dozen times, very clearly. And why would I not mention about the case? Right. Because that's what the court case is all about. And she goes on on the same page on the footnote, and you can read that to the audience.
It says, although the court could deem the first request as a request to vacate and set aside the certification, which is what petitioner seeks in the prayer.
Yeah, she is on. In one breath, she says, "Oh, it's moot. It is not moot because that's why I've come to the court. That this certification is illegal. Stop it, vacate it till this case is over." And she said, "Oh no, it's moot because they already decided." Yes, they decided they were wrong because I had already filed a case. They had time to stop, but they rushed it. And then on the same page, she said, well, you know what? Court could actually, you know, vacate the certification and set it aside. That's what you want, don't you?
Yeah.
And doesn't do it.
Exactly.
So
So, so she expected you to not read that footnote, or or
I don't know either if it was just a thought in her mind that she put there, but that describes everything. One thing she said is all wrong. Everything you're wrong. You're not going to win this case. You're not going to prevail. And then she says, although the court could vacate, set aside the certification, which is the juice of the case. Set it aside because
and
it's all
vacate.
illegal.
Yeah, although the court could do what you requested. the elections were certified on May 1st, so we can't do it. It doesn't make any sense.
No, first she says it's moot because they already decided. No, when I filed the complaint and I served upon them, it was not certified. They received the complaint and they rushed it. They rushed it and they certified it. And one of the orders, request order that I've set in the complaint, the TRO is set aside, vacate this certification. Other, I didn't say that. Stop. I knew that by this time they certified it. So my request was, please vacate this illegal certification. And she says it herself in the footnote that although the court could, then do it.
Exactly.
And this is what I mentioned in my request for reconsideration. And this is what I'm coming down to the American people, because if I'm going to get injustice, I'm not going to stop here. I'm going to go all the way to your Supreme Court to fight this matter and to show to the judges in the federal courts what's going on, and to the people. These are elected judges. They're working for the people, not for these officials. And you can see the tone that she is setting from page 1, that you're not going to win because I'm the one who's going to be your judge in your final hearing. And I think you're not going to get it. And the reason that she is giving a totally exceed the law, justice, reason, discretion, all those things that you can think about, because she's saying you provide no information there. Down the line, you will read, you have provided no statutes. And I point out to page numbers that have provided statutes. And then she goes and looks into 16100 election codes, and she says, and she attacks one code there. So I have experience from 2018 where I filed election contest, and every time I'll quote this, then say, no, this one doesn't work, that work. And if I've quoted that, no, that one doesn't work, this one. So this time on the safe side, I quoted a very serious election codes, but she picked on, there's a typographical error of section C. She picks on that. And I pointed out that I'm going after 16100A, which says official conducted was responsible for malconduct. And I'm saying, of course, Registrar Dean Logan is the boss of the precinct boards. He's the boss of LA County. He's number 1. And he's responsible for all the fraud that has happened. So I'm alleging fraud. That is malconduct. And if you look at EFG that I'm pointing out, she's saying, oh, he didn't even refer to that. And she's attacking the point, the weakest over there. So the whole process is to dislodge me, derail me, get my case knocked out on some technicality.
Yeah.
And not focusing on whether the fraud has taken place,
Yeah, they're not focusing on that. So basically, we're going to get to that 1600 one, but it says his primary complaint, however, appears to be that the county violated Elections Code 15101B, and then she emphasizes machine reading them.
I got to say something here.
Yes.
It is so important. The judge's main job, oh my God, is the interpretation of laws. And this is such a clear note. I'm telling you, the sword is hanging. The sword is hanging on the American people right now, because 15101B 50 describes the whole. It's going to eliminate it's going to just justify the whole fraud. If this law is not read properly, the sword is going to fall on our heads. And the law is so clear. Election code is so clear. It says that you can open ballots 10 days before the election only for processing. Not for ballot counting, only for processing of damaged ballots. And you know what she says? She justifies it.
Exactly. She said she goes with what they said. She goes with what they say. And I think it's really ambiguous what machine reading means. Like, it's really ambiguous.
There are 2 words: preparing for machine read and machine reading them. So basically, machine read is like when you scan, put the, if it's just a scanner, if just a scanner, so that the damaged ballot doesn't get stuck. Number one, and the second one is the able to read it. And
Yes.
those are write-in ballots,
Able to
or
read
other
it,
things.
but doesn't take note of what it reads.
Yeah. So basically, if there's a torn ballot and they fixed it, so it should be able to be read by the machine, and the machine be able to read the ballot. So the what is on the ballot should be able to go through the machine, and machine be able to read the ballot. And then it goes further and talks about, if you look at it, uh, write-in ballots but it doesn't say anything about scanning and tabulating ballots
Yeah.
10 days before the election. That's going to completely demolish our democracy. I'm telling you, the only right we have, our constitutional right, will be completely demolished, and we will be left with nothing if we don't fight it right now, because the process of election is at stake, my friend.
Yes. So let's keep going. Let's keep going. And then they emphasized on the machinery. Petitioners' allegations to the contrary. The plain text of 115-101B thus appears to authorize the scanning, i.e., machine reading, of vote by mail ballots starting on the 10th day before the election. The court finds that the petitioner is not likely to prevail on his claims that the county violated 115-101B.
Yeah, just read that line again. That line, that he not going to prevail, that the county did anything wrong. She is already deciding the case here.
Yeah, exactly. And then if vote by mail ballots are scanned or machine read prior to the election, 15101B says that vote cannot be accessed or released until 8 p.m. There is no allegation, it says in the petition, that the county
That's the point.
accessed or.
That's the line. I have the allegation. She's saying there is no allegation that county or registrar accessed the ballot. That's my main complaint. I've said over and over again that these guys, were crooks. They got together. They used this machine, which has two-in-one function, and they scanned and tabulated, counted the ballots 10 days before the election, and changed the results, and put me in number four.
Yeah,
I
that's your main
so
allegation that they did
yeah,
that
that's
they
my main.
did.
And the reason they put me number four is so that people would laugh at me and say, "Hey, he's number four. He's not even number three. And why is he complaining?" Because I know my position in my district. People love me. I've been working 20 years here with the people.
Yeah, yeah.
Everybody knows me by name.
So then they go into petitioner alleges only that on election night, presumably before 8 p.m., the New York Times called the election. New York Times called the election and does not demonstrate the county violated section 15101B. I mean, whatever. Okay, we'll skip that one. Petitioner alleges to the county election officials violated section 15360F, although it is not clear how.
Just imagine this. Just a second here. We're talking about 1% tally, and this is so important for the people to know how we are being judged. What's going on. We need reforms here. I explained that they did not use any election night comparisons, no tally sheets. They didn't have any material to compare and say, "Hey, this is the election night result, and this is how we count it," and they match up. So you know what the order is? If you listen to her order, she's saying, "I did not use the word report."
Exactly. That's what I was getting to.
She
It
picked up
says
one word instead of my saying. What I was trying to use was use simple words so the judge can understand that did not bring out the election night comparison results,
the
and
tally sheets.
which are also called reports. The
Yeah.
printout, the 3-4 pages that were coming out election night, that they would print out and bring it and show it to you. They call them reports. Basically, they are election night results. So she based this issue of election fraud on 1% tally, that I did not use the word report.
Exactly. She's focusing on the
one word. She using one word, and you know where she's getting that word from? The Secretary of State the registrar's response, their attorney responded by saying, "Hey, he didn't use the word report," and she incorporates that word, one word. That we're talking about murder here. We're talking murder of the whole nation. We're talking about the murder of laws. We're talking about the rule of law being burned here. And she's picking up one word that says, "Oh, why didn't you use the word report instead of election night results?" Excuse me, I'm saying anything to compare the election night results with so that we can come out with a comparison. This is all hoax. This is all rigged. This is all fraud.
You mean the same thing. Just the fact that you didn't use this right term, it just
One word.
invalidates everything, right?
Report.
Like that.
Yeah, and she mentions it. She mentioned, if you read it there, she says it that I didn't use the word report.
Yeah, so he said no tally sheets were shown, and Raji also said zero information was shared in this 1% public audit to maximize extent of secrecy. And so what the judge says here, what is lacking, however, is any allegation that the county's election official failed to include the report required by Section 15360F in the certification of the official canvas.
I'm saying out loud and clear, if you read the paragraph, I'm saying loud and clear that they did not have any tally sheets, no election night results were there to compare with. So what are you comparing your audit with? First of all, the audit should be right away. It should not wait 2 days. So what they do is they already pick up the ballot boxes that they're going to check and audit and fix them, rig them. Even then, they couldn't fix it. They couldn't even rig it properly. Even if you want to do the fraud, do it properly, man, so that we are not on the media talking about it. If you do fraud, make it foolproof or don't do it. Here's something that is so simple, laid out, that you're making a mockery. They're making a mockery out of the rule of law. A mockery out of rule of law.
I agree, Raji. So we'll continue going on. Almost done. Petitioner states he brings his actions pursuant to Elections Code Section 16100, which permits an elector to contest an election for the following reasons. They have A, C, E, E, F. That the precinct board of any member thereof was guilty of malconduct. E, that eligible voters who attempted to vote in accordance with the laws of the state were denied their right to vote, which I 100% think is very valid. I mean, you can go based off of that one.
I used E, F, G, and she goes on and attacks C, and which uses the word the defendant has given any elector bribe. But the second part of it says, or has committed any offense against, this is about Section 18,000, which talks about penalties. But she goes and says, you pick C. That one doesn't apply.
Yeah, because so she only focuses on C in her response.
Yeah, and she leaves out E, F, G, and A, the ones that apply. So basically, the court's focus is on microscoping, looking at some procedural defects, some technicality to rule out just to conceal, to hide. I don't know what the intention of the court is. I think maybe it is inadvertent. Maybe the judge just didn't get a chance to look at the complaint properly. But, I can't hold my voice back here. I cannot let the judge or anybody take away the voice of the people. I will be so aggressive in this court case, whether it's the judge, whether who it is. I'm going to bring out the truth, because I'm telling the truth. I'm going to be loud. I'm going to scream out, and I'm going to try to protect the voice and the noise of the people.
Right. So then she focuses on C, which says that you failed to address any of the statute provisions in his application, much less convinced he is likely to prevail on his claims that the respondents violated them. These provisions require proof. Hold on, let me keep going. Where else did I highlight?
Every paragraph.
Yeah.
She's pointing out you're not going to prevail. She's telling me that I'm going to be your judge, and I'm telling you that, but she has no evidence. She puts words in my mouth that you said this. I never said those things. And then she said, you didn't say this. And I've said it loud and clear, and I pointed out each page number and line number where I've stated those assertions over and over again about election fraud.
Yes. So here's another one I wanted to point out. As our Supreme Court explains, the purpose of an election contest is to ascertain the will of the people at the polls fairly, honestly, and legally expressed. By a wide margin, the voters have expressed their will. Petitioner proffers no evidence that suggests that voters actually preferred him to the top or three candidates. I don't know why they're focusing on that, because
she keeps looking at the fraud results. I have said these results are fraudulent, all of it. She's saying, but you came forward. But I'm saying these are fraud. We need a recount. Stop this thing. But
they're saying you don't have any evidence. But it's like, I can't get evidence because everything's behind closed doors.
And she said she could decertify and set aside and vacate the election results. She said it herself, that she could vacate the certification of election results, and then she's picking on the same results that are fraudulent and throwing that on my face and disrespecting me and trying to insult me by saying that, hey, who the hell are you? You're number four. You're nothing. You're
Yeah.
nothing. You got
Pre-
no chance.
pretty much in judicial terms, they said, "Oh, but you came in fourth," so it's like, "Oh, you're just complaining about
You're not going to be number
the
three.
process."
And I'm telling them this is how the game is set. Just do the recount and we will find out the biggest fraud of the century.
So here's another one I really highlighted a lot. Second, under subdivision E, an elector may challenge an election if eligible voters who attempted to vote in accordance with the laws of the state were denied their right to vote. Petitioner does not allege any eligible voter was denied their right to vote. He alleges only that there were long lines on election day, that some people had to wait over 2 to 3 hours to vote, and that some unidentified people walked away or left without voting. So,
Unidentified people, American registered voters, they're not unidentified people. They're not people out of the space. They're not people out of the country. They're American people who were so disgusted with what was going on. And I alleged it. I said 15th. I put in the amendment. I said people waited in line and they were denied their right to vote by voter suppression. And so many reasons that I've counted, their names were not there. I can go on and on and on and on. And this was all because of the setup that was made. People came to vote. People were in line. They came in to vote. They were there. It's not that they weren't there. They were there. They were denied the right to vote. Obstructions were created for them to go away. And this is what has happened. And that's the truth. And she is saying that I did not allege. I'm alleging over and over again. And I can give you, and I pointed out page numbers that I can point out right now.
right, in your response, and because you sent a
Yeah.
response yesterday, right? Okay, we'll get to that in a second.
Okay.
So, yeah, I just had to highlight that because that's so ridiculous.
I pointed to her by page numbers and line numbers where I've defined it categorically. That is the gist of the case, that voters were denied their right to vote. And that's one of the constitutional amendments that I've quoted out, 14th, 5th, and 15th. And they're just scrambling around everything else and trying to avoid the word fraud. I've used the word racketeering because of the $300 million of taxpayer money. And the way, if you read that paragraph that she's included there, because it's like a mafia operation there. It's like a mob that I'm dealing with. You go there, everybody's hushed. And the moment you go there, don't talk to this guy. Everybody is this, they respond to the boss. And Dean Logan is operating this racketeering organization. And it's like a mob style. The entire thing is a mafia. Nobody will talk to you because they've been told, don't speak, don't give any information. What are we becoming?
Exactly. It's ridiculous, Raji. And then the other line I highlighted there was petitioner cites no authority for the proposition that simply having to wait several hours to vote is tantamount to being denied the right to vote. Didn't you cite an authority, the LA Board of Supervisors?
Yeah, and the thing is, these are judges. They're supposed to see the fact that I cited that the Board of Supervisors herself is saying that. I'm not saying it.
Janice Hahn, she said that.
Janice Hahn, and I said that. I said my complaint is reinforced by Janice Hahn's statement, which is on record. It's a testimony. And she told Dean Logan, I was there, that Dean Logan, this is not acceptable. I'm extremely disappointed. This is not acceptable. And Dean Logan said at that time, I will accept consequences. He should have resigned there because he has massacred the rights of the American people. He has massacred the right to vote. He has massacred election integrity, and he has massacred the rule of law.
Okay, we are almost done with this. Let's see. Due to mistake, error, or misconduct, the votes in any precinct were so incorrectly counted as to change the result. Okay, so it says, petitioner states also that he brings his challenge pursuant to Elections Code 16101, which authorizes a candidate in a primary election to contest the right of another candidate to the nomination of the same office on the following grounds. B, the defendant has committed any offense against the elective franchise. And then C, due to mistake or error or misconduct, the vote in any precinct were so incorrectly counted as to change the result. That's like that's also one of your main allegations.
And yes, and she's saying, no, she's trying to get me there on 101. And she's going to say 101 is for if you are fighting a case with another defendant or another candidate. The same points are in 16100 too. If you look at 16100, those elements are covered. So I knew what they were trying to do, what they did to me in 2018, that if I use this, they're going to strike me off here on technical ground because I use 133 13314, and they say, "Oh, that's a pre-election challenge. You should have come before." I said, "But it once this says very clearly that you can only go if you find a fault. So if I find a fault, pre-election challenge also, Johnny, is a pre-general election challenge. It doesn't say it's a primary." Or it said pre-election challenge could be a pre-gen because election hasn't happened. And if I see fraud and I don't report it, then I will be doing injustice. It's not easy to fight a court case, Johnny. I'm telling you, I haven't slept for nights and days, and my office is just working on this. Everybody's like online trying to help me out, whatever they let. But I'm doing it on my own. I'm burning all my energy is trying to bring out the truth because I will not let it go. I will not. And they're trying to go behind the garb of the national, COVID-19, that they were expecting COVID-19, courts are closed, nobody going to fight it. I fought COVID-19 to go into open the court system. I'm the only guy who's able to open the court system by writing to the president that open the court. I have a case. This is about justice. This is about the people. This is about national significance. And God bless Judge Russell's, the presiding judge of the Sacramento courthouse, that he opened the court for me and allowed me to file my election contest by mail. But thereafter, all these people that I'm coming across, if you look at it, I want to publish this document, this denial of TRO on the basis of everything else other than justice. There's everything else other than justice. There is no justice. What happened to justice? But I'm going to fight it. I'm going to fight it tooth and nail, all to the point. But if you can understand it, people that I'm showing the court order are like so furious about this. How can they do this? Even I'm telling you, a middle school kid, I'm telling you, a 10-year-old or 11-year-old kid, can read it and understand that this is not just. You don't need an adult to look at this. Any child can read the 10, 11-year-old can see and say it doesn't make sense. It doesn't make sense. It should make sense to a common man, because look what I'm doing. I'm fighting for the people. I'm saying, let's do a recount. Show me the machine. Let's run it. These machines should not be used 10 days before the election because you've already massacred election code 15101B, and you have decided the election 10 days before the election. And plus, you have password. You can access those machines and you can change the results. The essence of 15101B, the law is that all ballots should be counted 8 p.m. What they're saying is, we just scanned the ballot, or maybe we tabulated the ballot, but we didn't see the results. So we're supposed to believe them? We're supposed to believe them? Come on. The biggest crooks on the planet. We're supposed to believe them? And the reason I'm saying biggest crook when I talk about Registrar Dean Logan is the fact that he has a history. He was in Washington State. He resigned from there. He was forced to resign from there because of election fraud. And then there are numerous complaints against this guy. It's loaded. You go to blogs, it's loaded. And then this guy goes and does a $300 million debacle on machines that didn't work. I want that money back to the American people. I want that $300 million, whoever they purchased the machines from. And you know what? Who said that? Janice Hahn said that she hopes she can get some of that money back. And I said, no, we should get all of that money back and penalize the people who defrauded the American people.
They need to go to jail for life, I believe. Okay, so
the machine is said to be purchased from Venezuela, and no detail is given thereafter that who from, is it the mob? Where is this machine from? Who is behind it? Are these people able to steal our election? Is there somebody who's going to manipulate the election for Venezuela? Come on, So
exactly.
We need to look into this.
So the last thing it says, instead the primary allegation, so she was talking about, she said subdivision E, which said that what was it? One of your arguments was subdivision E, that due to mistake, error, or misconduct, the votes in precinct were so incorrectly counted as to change the result. And she says, instead, the primary allegation is that the votes were counted too early, not that they were counted so incorrectly as to change the result. Subdivision E appears to be
I never said that. I'm saying there's election fraud 10 days before the elections. I'm saying that the ballots were counted 10 days before the election. I'm not saying they were counted sooner. I'm saying they were counted fraudulently. There's a complete fraud involved. These people are not with clean hands. These people are there with unclean hand. It's a mob-like operation. The whole mafia thing is in process over there. And unless there's a recount, unless public is there, unless people like you are there witnessing the machine, and this is done one time, you know, the judge herself is saying that she could vacate the certification. Why? Why would she? Because she knows if she could do that, we could have justice come out. There's there's only one statement throughout the court order that gives a little blink of hope, and that is when she says herself, and she admits it, that the court could deem to vacate the certification and set aside the election because that's what
Right.
I want. And they could
They
do it.
they could
And
have.
they could. And saying and that she would only say that because there was a possibility and the conscience was there. And this is going to go, and this is where I need my fellow Americans to come forward. I want them to participate in their right and their constitutional right to vote. If we delete this process, if we dilute this process, then we are going to dilute our existence. And I need those petitions to come forward. I need millions of people to come forward and say, this is not just one guy fighting this. We are all fighting with him because this is about election integrity. It's a non-partisan issue. It is an issue for all sides to come forward and say, okay, if we don't do this, then it's going to come and hit us tomorrow, or it is going to hit our next generation tomorrow. Or if these machines are controlled by outside forces, and somebody outside the country is controlling them, then then this is a matter of national defense, national security, whatever you call it. Somebody's got to come down. Some forces of FBI, Department of Justice have to come down. And this is the reason that I included, Department of Justice, Attorney General of the United States as a special party in this case. So maybe somebody will come down and see what is going on. Because right now I'm all alone fighting this, and they know that this is one guy. We can just get him out of the way, just push him off.
And that's why you started this petition. Let me just finish this. It says, as the above demonstrate, the court finds that petitioner is unlikely to prevail on the merits. It thus denies the application for a temporary restraining order in OSC without considering the balance of harms. Two final notes. First, the Secretary of State argues that ex parte relief is not necessary because there is more than ample time to resolve the matter on the merits without enjoining the printing of ballots pending the hearing on the merits. The court agrees with the Secretary of State. If petitioner acts quickly, a hearing on the merits of the petition could be held by late July or early August. That's the last.
Just for 1 second.
Yeah, that's the last thing I highlighted. So yes, go ahead.
Basically, when did they talk? First of all, when did they talk? When did Secretary of State tell her that this is going to happen? Because she's talking about their response. Because once, remember, there was a briefing schedule and they were supposed to respond by 22nd, and I was supposed to respond to their response on the 4th. But that briefing schedule was vacated, so that response is moot.
Yeah, this court order is moot.
That court order is moot, and the response under that court order is moot. And she's picking up that response where they were responding to my old TRO, and they were saying, hey, in other words, don't give the TRO, because if you give the TRO, that means he has a chance of winning. This is the thing. Whenever a TRO is issued, it means that the person who has filed the TRO has a chance of winning. So say, don't issue him the TRO. Please don't do that, because you know what? We're not printing the ballots anyway. No, here I'm talking about the fact is, if they're not printing the ballots and they're admitting they're not printing, then issue the TRO. That does it right there. If the party is saying, hey, we're not printing, so just finish it up, and you say, oh, so you admit not printing it by August? Okay, then there's a TRO till August, because they're admitting it. And the second thing would be, first of all, you are saying yourself that you're going to vacate the certification. She's admitting to two things, that they're not going to print by August, and you're saying you could do this, and yet she's not issuing the TRO. So this is not justice. This is not justice. This is height of injustice. And I have filed a reconsideration of her order, and I hope, God bless her, our justice system, that some responsibility prevails, and this TRO is issued. This is not going to harm anyone. I'm saying till the matter is decided. I'm not saying, this is forever. Issue a TRO, finish everything in 10 days, 20 days, but issue a TRO, vacate the certification.
Yes. Okay. So basically, that's what the court order said. And then yesterday, Raji, you sent a response to the court order, even though you didn't need to, right? Because technically it's moot, right?
No, basically, she filed an order saying that, oh, I've already denied your TRO, and now basically I'm screwed. And in other words, is now we are straight going to go into the hearing of the case. But if I don't challenge this order, this is going to become the word of the court. It will become the part of the record that, oh, this is wrong. So all things that she has denied will become truth.
Right. So
I had
that's
to.
why you responded. Okay,
I
I understand.
responded, said, this is not true. This is not true. This is not. Please reconsider your order. Because when I go to higher courts, I'm going to say, I challenge this. This is totally one sided order. This is judges exceeded jurisdiction, overlooked complete record. She didn't even see that order was moved, the one that I was supposed to reply by June 5th. And so that there's no information, there's no statutory ground, there's no. Basically, she just demolished my whole requesting everything is false. Yet she agreed to vacate the order. So I'm hoping.
She says she had the ability to vacate the order, but she just
I
didn't do
said,
it.
just do the recount, court order recount. Everything is going to come out the truth, right there, because they have very high speed machine. It'll take 1 day to do the whole thing. Do the recount. It's a small, not that big a district, and we'll find out the truth.
Right. So I really wanted, since, because I read through all the court papers. I read through your
I know you put nights after nights into this, Jonny. I know.
We put nights
I know
into
it's
this.
not easy. It's too complicated, especially the 15101B, the law that has been violated due to fraud. It's confusing. And, I spoke to a lot of friends of mine who are attorneys, and they had to really give a deep look, and they said, you are right. It is obvious that the law says
it's ambiguous, but then it's obvious at the same time. It's the sneaky language, but
the
then
headline is very clear. It says, under no circumstances can you access the ballots. At the same time, it says prepare. The code is you're allowed to do preparing of the damaged ballots for machine count, not for all the other ballots, only preparing the damaged ballot. It's not saying you start processing all the ballots. It's talking about only damaged ballots.
And then the judge sided with them because that's what they said.
That's what the explanation they received, one-sided. And she went and saw, and she said that I did not even allege.
Which is what your whole thing is about.
Wrongdoing. So I just pray that God gives us all sense, especially the judiciary, to look into the public interest. It's not about me. It's about the public prevailing in this case, because the election is about public interest of national significance. Because if we don't come out, and somebody has to fight this, and I'm here, and I'm so grateful to you, Jonny, and your institution, and I just hope that your institution grows up to be one of the biggest institutions in the world, because what you're doing right now is a common person like me, a congressional candidate, can appreciate it, that there's a big fraud going on. Nobody would listen. I tried to reach out to all the medias. Nobody would listen. And here you are putting nights and days trying to understand what's going on and bring it out to the people. But I want to appeal to the American people, my dear fellow Americans. I appeal to you.
And you're fighting.
Please join my fight. I need petition signed. All I'm asking for is justice. All I'm asking for fairness and equity. All I want is the truth to come out, so we can come out of this haze into the world of reality.
So Raji has a petition on change.org, and you can find that in the description below. It pretty much just explains everything pretty simply. It says, hold LARRCC, LAC Board of Supervisors, California Secretary of State for 2020 election fraud, and release vote count machine evidence.
I said LARRCC, Board of Supervisors, and Secretary of State responsible, for this act, because they have to come out and expose whatever wrongdoing that has happened and join the people in that instead of blocking us.
Yes. So, our viewers, please, we're aiming for 100,000 signatures because that would be pretty significant. This will be bring the courts under the eye of the American people. It'd be getting more news coverage. Please share, get everybody to sign it. We need election transparency. We need election integrity and democracy. Our rights have been tarnished, and it's time that we make a change. And we in this petition, if you read it, it's very plainly put. And we kind of went deep in this interview, but it's pretty well written down in this petition. And one of the main things I want to point out is at the bottom here, the solution. The solution. The solution says support our petition to bring massive attention to this case that Raji is currently fighting. The matter is currently in process in the Superior Court of California, where an admirable presiding judge under the COVID-19 pandemic emergency admitted the case by mail. The judges currently are siding with the election officials on their word without even taking one look at the alleged fraud. They have the power to prevent the biggest miscarriage of justice as well as prevent irreparable loss that is falling upon us all by the consecutive execution of these fraudulent elections year after year. The judge has the power to order and make public the viewing of evidence, among other powers. A direct order to vacate the illegal May 1st certification by Secretary of State Alex Padilla, a manual recount as requested in the complaint, public viewing of the 2-in-1 scanning and tabulation machines, provide to the public the operating manual of the machines, provide to the public the operational procedures of the machine, how it works, how people set it up and everything like that. Halt the printing of November ballots until an outcome is reached in this matter. Halt tampering. Halt the actions of the current election staff and Dean Logan. Create an independent public oversight committee. In reaching our signature goal, we can put pressure on the courts to perform these orders in the interest of the public and pave the way for more transparency in our elections. Please share and spread the message. Our democracy is at stake.
I'd like to add one point because when we talk about the rule of law and we apply straight on the streets and we leave the people at the helm of affairs, that's not fair. The rule of law should be applied equally to all. Nobody's above the law.
Exactly, Raji. And I just really want to thank you for coming on. I please everybody go sign the petition. The main things is that they they're siding with the election officials without even looking into any of the claims that Raji's making. They're just saying that, oh, well, you didn't provide evidence, but you have witnesses there, and they made statements, and then it's basically their word versus your word, and then the only
It's
other
not
thing.
my word. It's the fact is that they started counting the ballots. The machines are the evidence. The machines are tabulation machines. So I'm with evidence. There is evidence that these are 2-in-1 machines, and you started counting the ballots. There's no argument about that. There's no doubt about that. They have counted the ballots 10 days before the election. And all we need to do is, okay, bring the machines, let's check them, or just put the page of the operating manual online and let everybody see what is there. But they admitted that these were 2-in-1 machines, and they went back to their word, and then they said they were, and then they went back, they were not.
Right.
So
That's what happened the night of. You asked Jeff Klein and Alex Oliveira that if they were 2-in-1 machines, they went back and forth until Jeff Klein was saying yes, they were 2-in-1. Alex said no, and then they eventually agreed that they
asked other people in the LARC's building who don't want their names to be put forward. They confirmed that these are 2-in-1 machines, and you saw them election night. They were the way they were scanning. You could see the way they were scanning, and the results were coming out just like that, simultaneously. They were scanning and simultaneously tabulating the ballots. There's no hiding this fact, and they can't hide this. They have to show this. And if they've done this, they have massacred the trust of the American people in the integrity of the election. They massacred the Constitution of the United States. And I'm here fighting this. And they got to do the recount publicly so that we can have such a session and we can follow that pursuit in future, that these things should be public, that the election count and recount should be public. I'm asking for a public recount, a manual recount, because people will get involved. Why put $300 million in machines? Why cannot we put $300 million on the people? that create jobs for 6 months or 4 months or for a year or whatever. These could be highly paid jobs, but we need to get the money back. And I hope my word gets across. I'm so thankful to you, Jonny and Convo Couch, because you guys, God bless you. God bless you. And these are my words. You guys are going to be one of the top mainframe media institution in the world for what you're doing right now.
Thank you so much, Raji. This it really means a lot, and when we see someone doing something real and democratic and is acting like a true patriot like you are, that's we have to expose this. We've seen it with our own eyes, and you've seen it, and we see you're fighting. So we have to expose it, and we have to let the public know what is going on, who's fighting it, who's fighting for our democracy, who's fighting for what America stands for. So
Absolutely, absolutely. We have to fight for this great land. It's not about us anymore. It's about our next generation. And if we don't do it, they will hold us accountable, responsible for what we do now is what is going to come out for everybody else. But you know what? Right now, we need everybody to come out as warriors of peace, come out as true Americans, patriots, and help me join my hands, my fight in this good fight against crime, against fraud.
absolutely. And someone asked me to post the petition on the chat, so I'm going to put it in the chat here. It's also in the description here. Pasta actually did a super chat. He said he wanted to ask a question, but I wanted to do this interview. He said there are many cases of election rigging all around the country. Isn't it better to fight for solutions rather than fight against a system that is in bed with the people who fix these elections? I think what he's saying is that I don't know why you're going to the courts. Is basically what he's saying. I mean, I don't know.
Let me tell you this, because the way we are, the way our system is intermingled is because if you don't go through the court, you are seen as, oh, there is no material. It's just words. Oh, he just got up. He's just a sour loser. These people exist all over the place, and he lost. But when you go and do the talk with the walk, because we can talk all we want. Nobody's going to take us serious. That this guy went to court out of his county, went all the way to Sacramento courthouse, had thousands of paper that he had to go through and fought a case against a government machinery. Then it looks like you have some material because no. I see so many people who lose election walk away as if nothing happened. But I'm invested with my blood and my soul. And it's not about me. It's about the district that I serve. The people that their lives are not going to change because my opponent is served by special interest. If you look at the donors, the warmongering, and all those things goes on and on.
Yeah,
And
Brad Sherman's terrible.
yeah, and that won't change. But I'm going to change things, and I'm going to keep fighting because I'm completely opposite of what he is. I'm for the people. I want to make sure that people get money in their pocket, good paying jobs, their lives change, not to fill up the pockets of their donors or as far as defense contractors and whoever supports him. Defense contractors are good, but you can bring out the interests of the people first. People are suffering right now. Look what COVID-19 has done to us. People who were suffering are now crushed. Small businesses are dying. And it's very easy for the government to say, stay home. You will not come out. You will not work, and they're easing it out. But many people, I'm telling you, they're not going to be able to recover. The small businesses that have been hit with COVID-19 and they were, stuck at home, it's going to take a while for them to come out because they were going month to month. I know many families who had reserves of like savings of 3 months, 4 months, 6 months, some had just 1 month. And that money has gone. Now they don't know, they're having trouble with their landlords in rentals and all that, and business rentals and whatever little business if they had on a street or what it has taken a hit. And we cannot just expect them to come out of it by themselves. This is where true leadership comes in, that somebody goes and sits with them, finds a solution. I like the word solution based, and this is why I'm talking about solution based. And my complaint is about solution based, that do the recount. It'll expose me. It'll expose everyone what the truth is about. And I'm so passionately fighting this because I know I'm fighting for truth, justice, and integrity, and it's going to come out. And when we talk about The whole election process, we're talking about the person who's been elected by the people, not by the system that is rigged. A person who's rigged is selected by a rigged system is going to be loyal to the rigged system. A
Exactly.
person elected by the people is going to be loyal to the people. And I think every day matters in our life. There's no pause button in our life. And time is passing and we are stagnant. There's no room for people to make a leap into time and succeed because everything has come down to a slow motion. I want to do that for the people. I think it's my job to come out and say, you know what? I'm going to think, I'm going to find out solutions so we can raise the level of standards of living. The standards of living are the same they were 30 years ago. People are still, I see so many businesses that exactly in the same solution in the same position that they were, 20 to 25 years ago. And I believe that a true leadership can come around and switch things around. But for that, we need election integrity, because if we don't have election integrity, these guys will rule us endlessly. They will rule us endlessly, and they will make it more and more corrupt. They will make it more and more hard for real people, good people to come forward, because an honest man can't even imagine to enter into politics and to fight against this big wall of corruption.
And that's why we have you on the show. Raji, thank you so much. You are a true rebel, true American, true patriot. And we're going to keep fighting. I only see 6 people that have signed the petition, 4 people other than us. I see 60 people watching right now. Come on, go sign the petition. Please share it.
Come, help me. I'm talking about the truth here. Forget about the party lines. Let's be completely non-partisan and do the right thing. And American people, when it goes to their head, they will come forward. I look forward to it. And I remain extremely grateful to everyone.
You have it here, folks. Ladies and gentlemen, thank you so much for joining us. Go sign that petition, please, and share it. Please share it. We got to get to 100,000 people. We got to try and take this to the courts and see what can happen. Because if we show that the judge is really failing in their job, and as you can see in that response, like how they're focusing on his the language in it, and the fact that he didn't use his word, and citing solely completely with the other side. It's BS. So thank you so much, everybody, and Convo out.
Thank you so much, everyone. Thank you so much. I remain grateful.